Well, joining us now from our Edinburgh studio is the former leader of the Liberal Democrats, Sir Menzies Campbell, who is also an advocate and a QC. Sir Menzies, thanks very much indeed for coming in. It is perfectly fair to say, isn't it, that this was not foreseen in the incorporation of HRA through the Scotland Act, the amount of cases that would be coming before the Supreme Court in criminal appeals?
Well, there have only been two in the last 2 years, and the first of these, CADA, was about what happens when a person's taken into police custody and whether when he or she is in police custody they're entitled to have the services and the advice of a solicitor. And the most recent case, of course, is whether the prosecution has a responsibility to tell the defence of all of the evidence, even if the evidence might support the defence. Now, both of these are decisions which are entirely consistent with the principle of fairness, which lies at the very heart of the Scottish criminal judicial system. That's why when Alex Salmond talks about trying to create more light, one has to have regard, as your questioning did, to the fact that it was he and his Justice Secretary who created the heat in the first place.
But there is this very, very significant distinction, is there not, that if there is... And if the Court of Appeal here in Scotland says, no, you cannot get leave to appeal to the Supreme Court, then in fact you can bypass that in Scotland and go to the Supreme Court. Whereas if the Appeal Court in England says, no leave to appeal, you cannot do that. So there is this distinction already there, and that is unfair and unreasonable, isn't it? Well,
I don't think it's unreasonable, because you can only go to the Supreme Court if you ask for leave. And if they grant leave, and they will only grant leave if they're satisfied that there is an issue to be determined. The other point, which everyone seems to have missed so far, but I've no doubt the stellar cast of legal experts to which Alex Salmond consistently referred will certainly have to have regard to it, and that is the fact that all civil cases are capable of appeal from the Court of Session to the Supreme Court. And civil cases raise questions of human rights. I'm aware, for example, of a case involving liquor licensing, where a human rights point has been taken and may well go all the way to the Supreme Court. It would be very curious, wouldn't it, if criminal cases stopped in Scotland or went to Strasbourg on questions of human rights, while civil cases continued, as they've done for 150 years, to go to London.
Yes, so that was why I asked the First Minister about the issue of funding, given the civil cases go through at the moment. What do you make of the comments about the withdrawal, the potential withdrawal of funding made by the Justice Secretary?
Well, these were petulant comments, in my view, as was the comment that the English judges, not all English, of course, one from Northern Ireland, would only know about Scotland what they learned when they came to the Edinburgh Festival. Now, it's been a bad week, the truth is, for the Scottish National Party government, but it's been a very bad week too for the reputation of Scotland. And that's why Lord McCluskey's trenchant remarks about Mr McCaskill have received such consideration and even acceptance.
What do you make, though, of this potential proposal of a majority of Scottish judges on the Supreme Court as being one way forward, or also the possibility of a Scottish bench of human rights judges?
Well, no doubt these are things which the committee under John McCluskey will examine. But if I may say, just before I come to the substance of your question, Jim Wallace, the Advocate General, the person responsible for advising the British government on legal matters, convened just such a committee under the equally stellar chairmanship of Professor David Edward, formerly a judge in the Court of Session, but also a judge from the European Court of Justice. That's the court that deals with the European Union. So we've already had a review. There's going to be another review. I've no doubt they'll give consideration to the sort of issues which you referred to. But look, if the way this had been begun had been by saying, look, there is an issue here and we would like a group of Scottish lawyers to consider it, then no one could have taken objection. Where people have objected, and in my view quite rightly, is the atmosphere in which this has been conducted.
So, on a completely different subject, thank you for that, but on a completely different subject, there are reports in one of the papers today that RAF Lookers is going to be axed and turned into a tourist airport. I mean, do you attach any credibility to that?
Well, this whole idea of having Ryanair landing at RAF Lookers was current about 5 or 6 years ago. I have been assured as recently as last week by ministers in the government who will take the final decisions that no decision has yet been taken about either Lucas or Lossiemouth, and I continue as the constituency MP to campaign to the best of my ability, because I believe that the strategic case, the case for